Hi, everyone. Welcome to Crime in Court. This is Commonwealth versus Karen Reed Trial 2.0. We are on episode 128, continuing our motions in limine. And this is jury privacy and empanelment that we will be talking about today. So let's get started without further ado. This one's going to be a little bit of a shorter one because it's not as lengthy. The filings aren't as lengthy. So we'll get through it pretty quickly. All right, so let's get started. Please hit that like button. All right, so the Commonwealth's motion in limine to appoint court stenographer, prevent identification of jurors, and impound juror names during trial. So obviously, you can tell they want to keep the privacy of the jurors during the trial. They don't want their names published. The Commonwealth requests that the court appoint a stenographer for the trial and deem impounded the names of all jurors, and that sidebar discussions and juror names be unavailable to the public until a verdict is returned. Commonwealth also requests that spectators and journalists be ordered to refrain from attempting to provide specific identifying information of jurors or potential jurors to the public. The Norfolk Superior Court has traditional courtroom stenographers and, for the record, equipment to record courtroom proceedings. FTR recordings may be available less than 24 hours after the courtroom event without any opportunity for a party to have notice or an opportunity to object or for the judge to consider a request for access to a sidebar discussion. It appears that anyone can create a FTR account and request for access to a particular recording, which will be reviewed by the clerk who authorizes access unless there is an order of impoundment or other judicial process prohibiting access. So, for the record, what is for the record? Some kind of equipment to record courtroom proceedings. That's what they use for the stenographer, I guess, is what they're saying. So, the absence of an order of impoundment of all sidebar discussions could result in those discussions being publicly disseminated during trial and potentially prejudicing the parties. A showing of good cause may overcome the public's right of access to judicial records. In determining whether good cause has been shown, a judge must balance the right of the parties based on the facts of the case. Supreme Judicial Court has stated that good cause is readily apparent in circumstances including 1. The impoundment of the names and addresses of seated jurors during the course of a highly visible trial where the risks of inappropriate juror contact would jeopardize a party's right to a fair trial, and 2. The impoundment of the responses of jurors to highly invasive or personal questions posed during the individual voir dire. So it helps shield them from, it helps shield them from possible influence, and it helps also keep their privacy by keeping their names private, is what they're saying. So the defendant, law enforcement officers, and potential witnesses have been the subject of intense media interest and scrutiny. Members of the public have engaged in notable activities in conjunction with the prosecution of this case, including private citizens protesting at the courthouse and private citizens engaging in relentless harassment and acts to intimidate witnesses from testifying at trial. The consequence of these efforts has reached past jurors and a grand jury member. Security is also a significant concern. The publication of security concerns or measures discussed at sidebar would undermine the ability of the court to maintain order and could jeopardize the proceedings. How? By hearing sidebar conversations of why something can or can't come into to be heard in front of the jurors. That's undermining the ability of the court to maintain order. Really? That's reach. The publication of matters discussed at sidebar relative to jurors while trial is ongoing. Okay, that I get. If you're talking about jurors, then that should be impounded for sure. So the publication of matters discussed at sidebar relative to jurors while trial is ongoing, including juror names, information, and potentially sensitive responses to inquiry, could prejudice the parties and expose jurors to extraneous matters. The Commonwealth anticipates that after a verdict is returned, the potential prejudice to the parties will be greatly lessened, and that all parties of the record, except any of the court specifically finds subject to further impoundment for good cause, could be made available to the public. So after a verdict's made, if the court feels it's necessary, you can make all of it public. I don't care. Just for during the time of trial, please keep it impounded. And that's what they're saying. So all right, so the next filing is also from the Commonwealth. It is a motion for attorney conducted and individual voir dire of potential jurors and proposed jury questionnaire. So I kind of think that both of these filings from the Commonwealth are pretty common, pretty typical, standard stuff to be doing. Whether what's in their filings is typical or not, I don't know, but it seems like these are things that typically happen in the course of legal proceedings. So now comes the Commonwealth and respectfully requests that this court allow the Commonwealth to submit a written questionnaire to prospective jurors and allow the attorney conducted voir dire and individual questioning of each prospective juror to ensure that each person called as a juror stands indifferent to this case. Under Superior Court Rule 6, the trial judge should consider some individual voir dire in all cases to 1. Determine whether any juror has an impediment concerning hearing, language, or visual ability, mental health, or comprehension, and to determine whether a reasonable accommodation would enable the juror to serve. 2. Address any private or embarrassing information not disclosed in public portions of the voir dire. 3. 3. Identify any other impediment to jury service that the trial judge and parties might not observe without personal contact with the juror. So, personal stuff, or so it seems. Individual voir dire, anything that might be personal, private, or anything that might, someone might learn who they are from hearing about them. But any conversations that they're talking about, like their own disabilities or things like that, anything that's embarrassing, you want that all impounded. So individual voir dire outside the presence or hearing of other members of the jury pool increases the amount of information obtained from a prospective juror, thereby assisting the court and the parties to accurately assess whether the prospective jurors in this case are free from bias, interest, prejudice, and other extraneous influences that may undermine the impartiality and prevent them from fairly and justly deciding the case. The Commonwealth seeks to question prospective jurors about what is specifically referenced in their confidential juror questionnaire to determine whether the juror stands indifferent in the case. So those were from the Commonwealth. They want to do their own voir dire. They want to be able to ask the jurors questions, which is typical of voir dire. You have to ask them questions to learn who they are. So Karen Reed's team also filed a motion for attorney conducted panel voir dire. Theirs is a little bit longer, so let's dive in. All right, so now comes the defendant, Karen Reed, and respectfully moves this honorable court for attorney conducted panel voir dire of the jury veneer in order to determine whether such potential juror stands indifferent. So again, same thing, same common ground here. They both want indifference of the jurors or people who had never heard of it or haven't formed an opinion about it. So Ms. Reed requests that defense counsel be permitted to conduct panel voir dire of the jury veneer I can't talk today, on the following subjects: whether previous experiences with the jury system or criminal legal system, characteristics of the case, including the media attention or personal characteristics or concerns of the prospective jurors would impair the ability to be impartial. Whether prospective jurors are biased in favor of law enforcement or have law enforcement related knowledge. That's important because of the law enforcement role in this case and the possibility of law enforcement being corrupt and crooked. And I don't think it's just a possibility, I think it's a certainty, but that, I guess, is for the jury to decide. Whether the prospective jurors hold strong personal beliefs about operating a vehicle under the influence of alcohol, I think that's extremely, extremely important because I think that's what they got hung up on, that she was driving under the influence and she needed to be punished. That's what I think happened. Whether or not she hit John, they didn't care about that. They just wanted to punish her for driving and drinking and driving, in my opinion, some of them. All right, so whether prospective jurors had been involved in or have close friends or family members who have been involved in domestic violence relationships, whether prospective jurors or anyone close to them have been involved in a motor vehicle crash, whether prospective jurors have been the victim of any violent crimes, and whether prospective jurors understand and can be impartial in light of the procedural protections afforded to defendants in criminal trials. Ms. Reed reserves the right to ask reasonable follow-up questions to each prospective juror pursuant to the statutes. The argument here is that the statutes and the Superior Court Rule 6.3b, the Superior Court is required to permit the requested attorney-conducted voir dire. Part of the Sixth Amendment right of an impartial jury is an adequate voir dire to identify unqualified jurors. Prior to 2014, there was no right to attorney-conducted voir dire in Massachusetts, and whether to permit what? Prior to 2014, there was no right to attorney-conducted voir dire in Massachusetts. You guys are living in the frickin' Stone Age. I'm sorry. Your justice system is, anyways, and that explains a whole lot. A whole lot that explains. So you've only had attorney-conducted voir dire in Massachusetts for 11 years. What have you guys been doing since? I don't understand. Does not compute. I don't get it. Anyways, so prior to 2014, there was no right to attorney-conducted voir dire in Massachusetts, and whether to permit attorney-conducted voir dire in any given case was entirely within the discretion of the trial court judges. And that sucks if you have a biased judge and they're like, nah, you can't ask questions. And then every single person you get on your jury hates drunk drivers, hates people who they think did violence towards officers, I mean, all the biases that you can think of because you have a biased judge and she didn't let you ask them questions. Could you imagine if we didn't have this rule now in Judge Cannoni's courtroom? Yikes. Continuing on. However, in an effort to better protect the right to an impartial jury and ultimately a fair trial, describing voir dire as a way to examine whether the juror related to either party or has any interest in the case or has expressed or formed an opinion or is sensible of any bias or prejudice. Massachusetts legislature was amended through the amendment. The legislature created a right to attorney-conducted voir dire. The current version of the statute so amended states that, in addition to whatever jury voir dire of the jury veneer is conducted by the court shall permit upon the request. So you have to now because they requested it. Upon the request of any party's attorney or self-represented party, the party's attorney or self-represented party to conduct an oral examination. So somebody has to be able to, if they request it, you have to do it. They want a jury, an attorney or self-represented party to conduct the oral examination of the prospective jurors at the discretion of the court. See also other statutes. The trial judge shall allow attorney or party veneer if properly and timely requested. The Massachusetts Supreme Judicial Court has interpreted the most recent version of the statute as creating a right to an attorney conducted voir dire and accordingly has expressly stated that the trial judges must permit attorney conducted voir dire upon request. Accordingly, because this request for attorney-conducted voir dire was properly and timely made, the court required to permit attorney-conducted voir dire. So, as per Superior Court Rule 63A, on or before the final trial conference in a civil case or a final pretrial conference in a criminal case, or 5 business days before trial, if no such conference is scheduled, the parties shall submit in writing any requests for attorney party voir dire, motions in limine concerning the method of jury selection, proposed subject matters or questions for inquiry by the parties or trial judge, any proposed supplemental questionnaire, any proposed preliminary legal instructions to the veneer or jury panels, the location within the courtroom where jurors and parties will stand or sit during the voir dire and or other matters, setting forth the parties' position regarding the empanelment. This rule and the rule of Superior Court 2017 is where this can be found. The request for attorney-conducted voir dire has been submitted in advance of the pretrial conference as required, so they're reminding her, we've submitted this well in advance of the pretrial conference, well before the 5 days. I think we're on day 19 today, or I think it's 18. I think we might be on 18 today. I can't remember now. Hold on, I gotta look because this is gonna bother me. One sec. We are on 18 days away from trial, so it's approaching pretty quickly. All right, so the first point here says actually, it's the second point here. It says all questions proposed by defense counsel are consistent with the guidance in Superior Court Rule 6 and necessary to ensure Ms. Reed's Sixth Amendment right, and so should be allowed. While trial court judges must grant attorney-conducted voir dire when properly and timely requested, judges retain discretion over the scope of attorney-conducted voir dire. The court may impose reasonable limitations upon the questions and the time allowed during such examination, including but not limited to requiring pre-approval of the questions. Superior Court Rule 6 states the judges may permissibly use the discretion to place reasonable restrictions on the subject matter, time, or methods of attorney or party voir dire. Rule 63F of the Rules of the Superior Court, which was amended in 2017, and precludes attorneys from asking a small number of questions or particular subjects or Rule 6, Rule 63E of the Superior Court. That's what that's from, I guess. Okay. So critically, though, Rule 6 also includes guidance that judges should generally approve a reasonable number of questions intended to reach certain permissible ends or inquire into certain relevant topics. Rule 6(3)(c) of the Rules of the Superior Court state these questions include you could seek factual information about the prospective juror's background and experience pertinent to the issues expected to arise in the case. These are all the things that you are allowed to ask. Stuff about their background, experience that's pertinent to the case, the issues of the case. You may ask things that may reveal preconceptions or biases relating to the identity of the parties or the nature of the claims or issues expected to arise. You may inquire into the prospective juror's willingness and ability to accept and apply pertinent legal principles as instructed. And you may ask if they are meant to, or your questions are meant to elicit information on subjects that controlling authority has identified as preferred subjects of inquiry. So these are the like stick to the main topics basically and how it relates to your jurors personally. And can they apply legal principles to it and things like that. So those are the kinds of questions that you can ask a voir dire. Rule 6 also explicitly instructs that in doing so, judges should consider the goals outlined in Rule 6.1, which includes permitting parties and their attorneys to participate in the process of identifying potential juror biases. Rule 6.1 of the Rules of the Superior Court. And I believe did I miss reading this? I did. I missed a footnote from earlier. It says, as per Superior Court Rule 6E, counsel and parties may not ask questions framed in terms of how the juror would decide this case prejudgment, including hypotheticals that are close specifics to the facts of this case. Any hypotheticals that may trigger the rule must be presented to the judge before trial. Questions that seek to commit jurors to a result, including without limitation, questions about what evidence would cause the jurors to find for the attorney's client or the party, questions having no substantial purpose other than to argue an attorney's or a party's case or indoctrinate any jurors. Questions about the outcome in prior cases where the person has served as a juror, including the prior votes of the juror or the verdict of the entire jury. So you can't ask like, what did you vote on in your last jury, if you were on a jury before and things like that. How did you vote? What was the verdict? Stuff like that. You can't ask. Also, questions in the presence of other jurors that specifically reference what is written on a particular juror's confidential juror questionnaire. You're not supposed to ask because so if there's something that comes up in a questionnaire in an answer from a prospective juror on their questionnaire, you can't bring it up if it's like some private thing. Um, and make that if it's a confidential questionnaire. Confidential information is what I'm trying to say. Where did I leave off? I don't remember now. All right. Next point is the subjects that defense counsel has proposed for attorney conducted voir dire are subjects into which Rule 6 instructs inquiry should be allowed. Most of the proposed voir dire subjects will aid defense counsel in evaluating prospective jurors' ability to be impartial by eliciting specific evidence of relevant bias, such as bias and in favor of police officers or against people who are accused of operating a motor vehicle under the influence of alcohol. Consequently, questions on these subjects should be allowed as questions that seek factual information about the prospective jurors' backgrounds and experiences pertinent to the issues expected to arise in the case. Rule 6.3 of the Rules of the Superior Court 2017 and may reveal preconceptions or biases relating to the identity of the parties or the nature of the claims or issues expected to arise. All right, we're going to back up because I've got a footnote here that says specifically, defense counsel seeks to inquire of the jury whether previous experiences with the jury system or criminal legal system, characteristics of the case, including the media attention or personal characteristics or concerns of the prospective jurors, would impair their ability to be impartial, whether prospective jurors are biased or in favor of law enforcement or have law enforcement related knowledge, whether prospective jurors hold strong personal beliefs about operating a vehicle under the influence of alcohol, and whether prospective jurors have been involved in or have close friends or family members who have been involved in domestic violence relationships, whether prospective jurors or anybody close to them have been involved in a motor vehicle crash, and whether prospective jurors have been the victims of violent crime. So those are a lot of questions they want to ask, but that's a good roundabout overview, I guess, of what they want to ask. That gives us a good overview of what the defense attorneys want to ask the um, potential jurors during their voir dire process. So, discussing the value of and the value of encouraging questioning sensitive question. I don't know. I don't know why I'm struggling here. Discussing the value of and the value of encouraging questioning sensitive to the possibility that bias may arise out of the family relationship with law enforcement, even though a familial tie to law enforcement is not dispositive of bias. In view of the violent nature of the charge of homicide, it would have been preferable had the judge asked the veneer collectively whether any of the prospective jurors uh, or a member of their immediate family had been the victim of a violent crime. Sorry, it was like faded. I couldn't tell what it said. We would expect judges to ask the questions in cases of violent crimes. Have you ever been the victim of a violent crime? Have you ever been the victim of a drinking and driving accident? Have you ever been the victim of a um, violent, beat down from some thug? Brian, I am talking to you. Um, with respect to proposed questions on the subject of the bias due to media attention in particular, Massachusetts courts have recognized the potential biasing effect of extensive pretrial media coverage on a case. Quoting Commonwealth versus Tulin, where pretrial publicity renders the risk of juror bias particularly acute or especially significant. Both this court and the United States Supreme Court have emphasized the need for an adequate voir dire. Ms. Reed's case has been highly publicized in both Massachusetts and nationally. Since this criminal case began, newspapers and news networks, including the Boston Globe, Boston 25 News, the New York Times, Vox, NBC, CBS, and the Washington Post, to name a few, have been covering Ms. Reed's criminal case, some publishing about the case repeatedly over the course of 11 months. And they just give a whole bunch of clips and articles and things discussing the Karen Reed case. So, given the significant media coverage of this case and the resulting likelihood that many potential jurors will have learned information about the case through the news, it will be particularly difficult to impanel an unbiased jury for Ms. Reed's second trial. As such, allowing defense counsel to question jurors on the subject of media attention the case has garnered is necessary to ensure the impartiality that Ms. Reed is constitutionally entitled to. Questions on the remaining proposed subject of whether prospective jurors understand and can be impartial in light of the procedural protections afforded to defendants in criminal trials should be allowed as inquiries into the prospective jurors' willingness and ability to accept and apply pertinent legal principles as instructed. You have to be able as a juror to apply legal principles, and you have to, in order to know that they can do that as an attorney, you have to be able to ask them if they can and give them some possible scenarios and things like that for legal, applying the law. Rule 63C thus affirmatively counsels that each of defense counsel's proposed voir dire subjects should be allowed. Letter B. Ensuring Ms. Reed's constitutional right as an impartial jury requires allowing inquiry into the proposed subjects. Allowing defense counsel to inquire into the proposed subjects not only complies with Rule 63C, but is also necessary to protect Ms. Reed's right under the Sixth Amendment of the United States Constitution to an impartial jury, which hinges in part on adequate voir dire. C. Morgan. In this case, adequate voir dire requires not only that this court follow the Supreme Judicial Court mandate to grant a timely and proper motion for attorney conducted voir dire, but also that the court allow attorney conducted questioning on proposed subjects that meaningfully aid in the identification of unqualified jurors. Voir dire plays a critical function in assuring that criminal defendant that his constitution right hold on, let me restart that. Voir dire plays a critical function in assuring that the criminal defendant has his constitutional right to an impartial jury and will be that his right will be honored. Without an adequate voir dire, the trial judge's responsibility to remove prospective jurors who will not be able to impartially follow the court's instructions and evaluate the evidence cannot be fulfilled. Rule 6 and rules of the Superior Court. That's where that came from. All right, so this rule provides a standard procedure for each civil and criminal case unless otherwise ordered by the trial judge while permitting attorneys and self-represented parties a fair opportunity to participate in voir dire so as to identify bias. Given that defense counsel's proposed questions contravene no part of Rule 6, fall within the type of question which Rule 6 counsels should be allowed in reasonable number and are necessary to ensure adequate voir dire, and thus Ms. Reed's constitutional right to an impartial jury, this court should permit defense counsel to inquire on all subjects included in its proposed jury questionnaire. So they already proposed a questionnaire for the jury that they're going to ask their questions based on that. And so that's what they're saying. We should be able to ask all of our questions. And they gave complete case law as opposed to the 2-page nothingness of Hank Brennan asking for um, oh wait, that was for the privacy. No, it's a one pager. Well, it does roll on to the second page, but it's mostly a one pager where he's actually asking for a attorney conducted voir dire of the jurors. And then you've got the defenses, which is 8 pages long, and they give you case law and they give you reasons and background and all sorts of good stuff. Whereas the Commonwealth is like, I'm not even trying with my motions anymore because Judge Bev is just going to approve it. So why even bother? So they don't care if it's accurate, if it says the right case law or not. They're just like throwing darts on a dartboard and saying, yeah, I'm just going to go with this excuse as to why I want it. So at least that's what I'm seeing. What do you guys think? Let me know in the comments below. Please hit the like button on your way out, and I will see you guys in the next one. Take care. Bye now.